Anyway.
Okay, Miss Antley,
But
if you're laying down, you need to sit up. You're in court.
until October.
I mean, you really don't have to send it as long as you do it. You could just send it like.
Miss Antley, you need to sit up. You're in court.
Like
I only
that.
sent you about 20 hours or so. I don't remember.
Okay, you can turn the video, turn your Zoom off and turn it back on, and then you'll have it won't be on mute.
Missing some hours, but there's plenty on
You're not missing, you're not missing on here. But it's on you. Thank you, I appreciate it.
Miss Antley, your mic is on mute. You can turn your Zoom off and then turn it back on. It'll be off of mute.
I know, and he told me, he put me on mute.
Hey, nothing happened. Relax, on your time.
Do you need his
Who are you, sir? I'm doing.
you can give him a copy of his reset.
Jordan.
I'm right here.
Okay, now Ms. Antley, make sure that you sit up. You're in court. You need to conduct yourself accordingly. Can't
I'm
let.
sitting up.
What did you say?
I'm sitting up.
That's good. Make sure you continue to sit up. Okay, when we call your case, then you can take your mic off of mute. Thank you.
I don't know how to take the mic off of mute. You know what he's talking about.
Well, Ms. Antley, we can hear everything that you say. If you can't
I
take,
don't know how to take my phone
if you
off of
can't-
mute.
okay, if you can't take your mic off of mute, please remain quiet. Okay?
Mm.
Okay, is that Joshua Janice? Make sure your mic is on mute. As a child, we can hear in the background.
It's my cousin. We can approach because he is a child.
I understand.
I don't know if he's gonna be able to.
Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. This morning, we have 3 dockets. We have our jury trial docket, our announcement docket, and our pretrial conference docket. When I call your name, please come forward with your attorney. And if you're on Zoom, take your mic off of mute. If your attorney is not here, we'll wait for your attorney to arrive because your attorney may be in court handling another matter. If you're not represented by an attorney, when I call your name, please come forward by yourself. I'll turn your mic on mute. Take your mic off of mute, wait, if you're on Zoom. First case is cause number 24 CCCR 3014, case is style of the state of Texas versus Mandy Antley. Miss Antley is on Zoom. It's on the trial docket. And Miss Antley, how are you doing?
I'm okay.
That's good. And Miss Antley, you're represented in your case by your attorney, Attorney Jennifer DeLodge. And Ms. DeLodge, how are you doing?
I'm doing great, Judge. How about you?
I'm doing fine. Thanks for asking. The state is represented in this case by Attorney Haley Simmons. Ms. Simmons, how are you doing?
Great, Judge. How are you?
And Ms. DeLodge, what's your announcement, Ms. Antley?
Judge, we have made an agreement with the state, and that agreement requires the charge to be lessened to a Class C misdemeanor. She's going to make a payment in JP court on October the 2nd.
Okay.
But she couldn't do it till then, so.
All right, understand. Okay, so we're gonna reset this case until after September the 2nd. Give us,
October, I can't.
excuse me, October the 2nd. Give us a October reset date. Probably gonna be on pretrial.
Pretrial conference is fine.
October 27th.
Okay, is that enough time?
Yes, Judge. She
Okay.
should have it done by.
Okay, so the case is reset to October 27th, you said?
7th, yes.
27th. Now, it's gonna be on a pretrial docket. Now, Ms. Antley, if the payment is made before October 27th, you need to get that receipt to your attorney so she can give it to the DA's office. And then your case will be dismissed. You will not have to appear in court on the 27th. Okay? Stay in contact with your attorney. You're free to go, and you have a blessed day. Okay, let's see.
Judge, I
Miss.
think that's all I have on your.
Yes,
Not free to go.
yes, you are.
Thank you, Judge.
Next case is Joshua Janice. Mr. Janice is appearing via Zoom, and Mr. Janice is represented in this case by his attorney, Attorney James Paget. Mr. Janice, how are you doing?
I'm all right. What about you?
I'm doing fine, thanks for asking. And Mr. Paget, how are you doing?
Doing well. Good morning, Your Honor.
Good morning. And Mr. Paget, what is your announcement in Mr. Janice's case?
Your Honor, discovery's been completed. I have an offer from Ms. Simmons, and I'm going to apply for pretrial diversion today. So regardless, either he's accepted or not, we have alternative offers. If you could have Mr. Janice appear in person on his next setting.
Okay, the next,
It will be disposed of one way or the other.
okay. Give us a reset second week in December. I think she was set, I think she was setting it for the 15th. Because that's
I understand.
pretrial diversion.
That's the first Thursday.
Right.
So anytime after that is fine with me.
I put it on 15th.
Whatever.
No, whatever date is
Please,
fine, but I was just trying.
Okay, December 8th.
Okay, this case will be reset to December 8, 2025. Mr. Janice, you need to be in court on that day, December 8, 2025 at 9 a.m.
Okay.
All right.
Yes,
Stay in
sir.
contact with your attorney and your bondsman. They will be given notice of your reset date. You're free to go, and you have a blessed day. And take care of that baby of yours.
Okay. I'm sorry.
Okay. All right. You have a blessed
All right.
day.
You too.
Okay.
And my other client, Mr. Minifield, who also
Yes.
should be on Zoom shortly.
Minifield.
Exactly.
I see Kenneth. I don't see
I
a,
don't think he's on there yet, Judge. He
Anything.
won't be.
no, I don't see a
Okay, I just wanted to let the court know.
Okay,
He should-
okay,
I just
okay,
confirmed
hold
with
on.
him. He should be, he's trying to get on that.
Okay. This case was, this class C misdemeanors.
Yes, Your Honor, it was transferred to the law. The law's party right there. Jeffrey Pope on the house.
Oh,
right there.
he's on page 7 of the announcement docket. Okay, this is, yeah,
Right here.
please stand in the front, sir. This is, okay, we have cause numbers 25 CCCR 0001 and cause number 25 CCCR 0002. Both cases are styled the state of Texas versus Jeffrey Scott Pope. Mr. Pope, is that your full name?
Yes,
How are you doing, Mr. Pope?
good. Mhm.
I'm doing fine, thanks for asking. Now, let's see. Mr. Pope, your cases are set on the announcement docket. It also shows that you are pro se, which means that you are representing yourself. Is that
Yes.
correct? Okay. Now, have you had an opportunity to review the discovery, review the state's file?
I looked at it and was thrown out. Under Article 34, I've got paperwork over there. It allows me to take copies or emails, whatever. I'm not.
What
restricted.
article is that? You said
It's
34.
in my paperwork.
Okay, hold on a minute.
DA restricted me from easy access to the paper.
I think it's 39.
And
15.
I'll be filing something on it,
Okay, hold on a
as
minute.
well as no jurisdiction.
Okay.
And I
That's-
need them to prove jurisdiction.
Okay, that's pretrial motions that you're talking about?
Nothing has been filed. but
Okay, he said, yes.
He did come into the office. We had a scheduled meeting where he was to review discovery. At that time, he came into the office, and I think you're aware, he was told at the bench that he was not able to have actual possession. He was able to come view it, at which time we made the meeting. He came up there. He was extremely hostile to the investigator who's down here today. Yes, Your Honor, he was.
I have a
Let,
recording.
okay, let one person talk at a time. We'll give you an opportunity to talk.
Okay.
Furthermore, I think the confusion started when he came in there and attempted to take pictures of the discovery, which duplication is not allowed, which is when he became irate. At that point, he was removed.
No, she's wrong. The confusion started, and I've got a recording of it that you can clearly see that I was not irate. I was talking to the lead investigator. I asked him who changed the charges. He's the lead investigator. He threw it up. I don't know. I don't know who changed it. That's not part of my responsibility. You can't just go and change court documents. That is illegal. Okay. I wanted to take pictures. I asked him if I could take pictures. He said, I'll have to check and see. I told him, you better come back with the right answer. Because if you don't, I'll file charges on that. And that's when he became irate. I'll throw you out of the office. I'll trespass you. And I've got it on recording if you want to hear it. It is not irate like this lady leads it to believe.
Okay,
I need jurisdiction, proof of jurisdiction on this case.
well, you need to file your pretrial motion.
I will file it today.
Okay, that's fine. Now,
We can't go further until I've got proof of jurisdiction.
we're not saying we were going any further.
Okay.
I don't know what you got.
The law requires that you or the DA, whatever, require or shows proof of jurisdiction.
That's not a problem.
Your Honor, the investigator's here who actually spoke with him if you're willing to speak with him as well.
I've got the recording right over there
Okay,
where it's not he said, I said.
okay, let me do this. Now, pursuant to Article 39.14, subsection D,
Mhm.
small letter D, it says that in the case of a pro se defendant, if the court orders the state to produce and permit the inspection of a document, item, or information under this subsection, the state shall permit the pro se defendant to inspect and review the document, item, or information, but is not required to allow electronic duplication as described by subsection A.
Mhm.
Okay?
Okay.
So the state is not allowed to, you can look it up as the Texas Code of Criminal Procedure.
Okay. And Texas 34 states that you cannot make it intentionally harder on a person. They give the emails to attorneys and stuff, but they obviously won't do that to a pro se.
Well, it's all in, you can read Article 39.14.
Okay.
It's titled Discovery, Texas Code of Criminal
Okay.
Procedure.
But you have to prove jurisdiction first.
Well, you have,
Because the thing stops with no jurisdiction.
well, you have to allege that the court does not have jurisdiction in the motion, and then we'll have a hearing to determine
Okay.
whether or not the court has jurisdiction or does not have
And would we
jurisdiction.
like the constable or whatever DA or investigator come up so he can
Mr.
perjure himself?
Mr.
And I'll play the recording.
Okay, well, this court is not,
He was fixing to.
okay, well, this court does not have a motion before it for a hearing. You're representing yourself, and I know I mentioned to you at the beginning, at the onset, when I gave you the Ferretta warning, and it's basically, I told you that you're representing yourself. I, as your judge, cannot help you in no way.
Mhm.
You'll be held to the same standards as a lawyer.
Okay.
Okay? So you just have to file the necessary paperwork so that you can put the matter before this court, and the court will hear this matter. Okay?
That's fine.
Okay, so we'll
So
give
you
you,
don't
we'll
want-
give you, this matter right now, I'll give you a chance to review section 39.14, subsection D. Well, actually, you can review the whole article 39.14. It talks about, it's titled Discovery.
Mhm.
And then you'll be able to perhaps answer some of the questions that you have. Okay?
Okay.
All right, so this case will be reset. And we're going to give you an opportunity to file the necessary motions
Okay.
that you previously stated that you will be filing. And then we'll set those motions for a hearing. And then we'll have a hearing on the matter.
But if the court can't prove jurisdiction, all this is irrelevant. The
Oh.
harassment by this
Okay,
officer, everything is irrelevant.
okay, we'll cross that bridge when we get to it. We're not there yet because you haven't filed the motion. You're saying that the court does not have jurisdiction. You just have to file your motion and we can hear the matter.
I'll file the motion.
Okay. So let's reset this case to give him time to file his necessary paperwork. And then once he files his necessary paperwork, then we'll set it for a hearing. Okay, so this case will be reset to October 27th, you said? Okay. What day of the week is that?
29.
Oh, we probably need to put it at toward the end of the, because our court was, hold on a minute. We put our pre-trial hearings at the end of the week because at the beginning of the week, we usually have trial.
Okay.
And so we can't do all of it at the same time.
We have a court
We can't set it for a hearing now until you file your motion. So you need to file your motion first.
Okay.
So we'll reset it just as a pre-trial matter, October 27th. We won't hear the motion at that time, but
As officer.
Okay, get your reset. Once you get your reset, you'll be free to go and you have a blessed day.
Wow, thank you.
You're welcome. Okay, you excuse. Next case is cause number 24 CCCR 1378. Case is filed the state of Texas versus Quentin J. Hall.
Your Honor, I spoke with the defense attorney on this case earlier. The state's gonna ask for an oral motion for continuance. A new witness has come forward and the state asked for time to speak with them.
I'm gonna hold up on, I mean, this case is,
It does have evidence pertaining to the defendant.
Yeah.
Crucial to trial, Your Honor.
okay, let me just have a seat. I'll hold on that right
Yes.
now. Next case, just have a seat, sir. Next case is Roderick Lanier Chillman Jr. This is cause number 23 CCCR 2310, case of style of state of Texas versus Roderick Lanier Tillman Jr. Mr. Tillman, is that your full name? How are you doing, Mr. Tillman? That's good. Mr. Tillman, you're represented in your case by your attorney, Attorney John Macy. Mr. Macy, how are you doing?
I'm fine, Your Honor. Thanks for asking.
You're welcome. Mr. Macy, what's your announcement in Mr. Tillman's case?
We're ready for trial, Judge.
Okay, state.
State's ready.
All right. Mr. Tillman, you need to be back this afternoon at 1:30.
Yes,
Trial. All right. Okay, he has two cases.
Yeah, he has two cases, Judge.
Okay. Okay, be ready. Be back for 1:30 for both those cases.
Thank you.
Now, hold on, Mr. Tillman and Miss Simmons. State is you're announcing ready on both cases?
Yes, Judge.
I'm announcing ready and I know you're holding on my oral motion for continuance on call, Your Honor.
No, oh, yeah, but I'm saying
I'm ready on Tillman.
on both of them.
We're just proceeding with resisting, Your Honor. We're dismissing the criminal trespass.
Oh, okay. All right. You can come back at 1:30.
No, we have Mr. Minifield on the phone. Your Honor, do I have another case?
Hold on a minute. Hold on a minute.
Oh, sit.
Quentin, hold on a
This
minute.
was on my calendar. I don't have a recent for the day, but.
I don't, because it's not supposed to.
I thought it was a trial.
I've never seen that on my trial.
I don't see another, you can check with, the
I've
court
never
coordinator.
personally seen it, Your Honor, so.
Check, he said he
It
had
was on
a,
my calendar, Judge.
yeah, just check with the court and she can let you know what the court date is.
Okay.
You have,
Mr. Minifield's on the telephone.
okay. We're gonna have to move him over.
John. Anyways.
Okay.
Okay. That's all announcement.
Yes, it is.
We have, he's on, okay, this is, cause number 25 CCCR 0886. Case is style of state of Texas versus Kenneth Ray Minifield. Mr. Minifield was trying to get on Zoom. He was having problems. The court, giving permission to appear via phone. Mr. Minifield, can you hear my voice? How you doing, Mr. Minifield? I'm doing fine. Thanks for asking. Mr. Minifield, you're represented in your case by your attorney James Paget. And Mr. Paget, what's your announcement in Mr. Minifield's case?
Your Honor, again, the same announcement as last time. I'm applying for pretrial diversion on Mr. Minifield today. I have an alternative offer. We just need to all be here in person on the next court date, and we'll dispose of the case either by, it'll already be disposed of by pretrial diversion, or we'll accept the state's offer on that date.
Okay, Mr. Minifield, your case will be reset till December 8th, 2025. Give your attorney opportunity to apply for pretrial diversion. On that day, December 8th, 2025, you need to be in court in person at 9 a.m. Stay in contact with your attorney and your bondsman. You're free to go, and you have a blessed day.
Disregards, I got a court date of September 2025. Disregard that date also.
Not on our case, Mr. Minifield. This case was set today. The only date, I'll send you the court date today.
That's the reason why I show up at the same October the 1st, at 9 o'clock. That's why I come to the courthouse this morning to my attorney called. I didn't know I was supposed to be present. Other than that, I'd have been there.
That's fine. Just, I'm gonna personally call you and give you the court date myself today. Just wait for my call. Okay, take care, Ken.
Okay, Mr. Paget, this last case.
But it wasn't me. Anyway, yes, Your Honor.
Okay, you're free to go, and you have a blessed day.
Thank you.
Your Honor, may I approach you again?
Okay, okay, hold on a minute. We have to get a prosecutor.
Whatever's easiest for you. Yeah, whatever's easiest.
Hold on. Okay,
Your Honor,
this is Shy Brooks.
no, he's down getting sentenced in felony court, Your Honor. But here's what's going on. He's got 4 or 5 misdemeanors. He's getting 10 years straight probation in the felony court. And
We got, he had 3 misdemeanors here.
I got more than that, Judge.
Let me see.
Is it,
Well, I think he got 2.
Cell phone silent, please.
He got 2 on the first one, and I think there's a collision case where he's got 2 pending collision cases. So he may have 4. You may be right.
no, I only had 3.
Okay, well, that,
3.
but what we,
No, the one of them was the 2 collision cases are here, plus the unlawfully carrying a weapon.
yeah, in my offense report, I have a resisting search or transport too.
Well, it's not filed here.
Says that was disposed of on 2/2.
Oh, it was already disposed of?
It shows, I need to see what it was disposed by. It's like a no contest plea,
Okay,
so.
we basically then have 3 cases, and one of them involves some restitution, and we need to visit the restitution number.
I think all of them do, Your Honor. We have to separate it out. There's quite a bit of receipts in this.
Now,
document.
let me ask you, the felony case was occurred at the same time, the same criminal episode. Do you know whether or not he was ordered to pay restitution in the felony case?
It was an evading, Your Honor, so I don't believe so. It would be handled with the misdemeanors, and that hasn't been updated in the system just yet.
What I'm asking for the court is give us a little more time so we can get the restitution.
Okay, we've reset it 2 weeks.
That's fine, Your Honor.
Yeah,
Okay, I was gonna say, I'll come back down here, Ian, let me make sure.
yeah, we need to get these things need to get out of the way. I mean, the felonies is over, so we don't need to keep these cases on the docket.
It hasn't been updated yet, Your Honor, so I don't even have the current disposition on the felony as of yet.
Okay, 2 weeks.
Yes,
If they'll send me a reset, I will put it down. Or I'll put
Okay.
it on my calendar now.
what's your court date? Yes,
October 13th.
okay, these cases rather reset to October 13th, 2025 at 9 AM. And I guess you can get your recess to Mr. Brooks, Miss Brooks, Shy Fake Brooks.
And I just need to get the rest of it.
Middle name is Fake.
Actually, maybe come back to California. I'm gonna invite the other board with the shit. And the circle with paper in front of Monterey is coming to California.
Okay, so
That'll be, yeah.
your cases will be reset.
Thank you.
All right,
I'll let you know.
okay,
I think gigs.
all right, you're welcome.
One of those days.
Volume, okay. I just slow down.
And Mr. Reynolds, how are you doing?
Well, good.
That's good. Mr. Reynolds, what's your announcement in Mr. Laurie's case?
Judge, Mr. Laurie, this case is supposed to be resolved by Mr. Laurie's payment of restitution.
Okay,
He hasn't paid it today. I know the state's ready for trial, but if the court would grant maybe one more reset, I believe he could pay it. We'd save a trial. He says he can have it this week.
Yes,
you say you're gonna have it this week?
yes, sir. I can borrow it before Friday, or I can pay it out of my paycheck on Friday. I mean, I can't go borrow and collect, not do that, but I mean, I can. I have to.
Okay, state,
The state's announcing already, Your Honor, just because we had the same announcement at the last setting. I believe he was gonna have time to make the payment.
oh,
on
you,
this
you did?
Last setting we approached, he was to have payment on this trial setting.
Is that correct?
That's correct, Judge, and
Oh,
he's a little short, so he's.
Yeah, I had
unable
a,
to pay it.
I had a, pen was a little short. I mean, I can get it today if you need it. I mean, I'll read it today. I have to, just,
You can get it by 1:30.
so I'll do it.
Okay,
Make it happen.
well, we'll see you at 1:30.
Pick the jury, Judge. I'll
Right.
order the agreement we have.
Okay,
Okay,
we'll see him at 1:30 then.
all right, yes, sir.
Okay.
Thank you.
He didn't hear me. J. Jesus Marcial Sierra is on Zoom.
Yes, Your Honor.
Okay, how are you doing?
Good, how are you?
I'm doing fine, thanks for asking. And you're represented in this case by your attorney, Jerry Gilthorpe. Mr. Gilthorpe, how are you doing?
Doing well, Judge, thank you.
Okay, and Mr. Gilthorpe, what's your announcement?
We're ready on that one, good.
State?
State filed its first motion for continuance, Your Honor, the expert, or I'm sorry, one of the officers is not available. I can print that motion if you need it.
They can give it to me. Hold on. Oh, here it is right here. This is state's first motion,
Yes, Your Honor.
and Mr. Gilthorpe?
Unopposed, Your Honor.
Okay, so this motion will be granted. Okay, give us a reset. We're gonna reset and keep them on the trial docket.
Thank you.
November the 3rd. Okay, this case will be reset for trial November 3rd, 2025. And let's see, we had the state's motion, first motion for continuance is granted.
Thank you, Judge.
Okay, Mr. Gilthorpe, you can get your reset. And Mr. Gilthorpe, you can see if you.
That's the only case I had, Judge.
Okay, Mr. Gilthorpe, you're free to go, and you have a blessed day.
Okay, so you can disconnect now.
And stay in contact with your attorney.
All right, thank you. Bye.
Right, you're free to go.
Thank you.
You're welcome. Okay, we have, next two cases are cause numbers 24 CCCR 2816 and cause number 24 CCCR 2817. Both cases are style of state of Texas versus Helen Kathleen Reyes. Ms. Reyes, would you please come forward? And Mr. Okay, how you doing, Ms. Reyes?
Oh, I'm very well. How are you, Judge?
I'm doing fine, thanks for asking. Now, Ms. Reyes is pro se.
Yes, Your Honor.
She, in fact, Attorney Andrew Hubel was handling these cases. Mr. Hubel has been transferred to another court. But Ms. Reyes has recently filed a motion. We had a previous hearing on your other motion.
Yes.
However, you have
Filed two
since
more.
that you filed two more motions.
And I need to file two more items. Yes.
Okay, well, we can do this.
Sure.
You stated that you need to file two more
Yes.
motions.
Yes.
Oh, so what we can do is give you an opportunity to file those motions. And then we'll can set all of these motions for hearing at the same time. Okay? All right, so let's do this. I'm gonna just give you a reset date. At that time, when we come back, then we'll set a date for to hear the motions. Okay? All right, so just give us a standard reset date. Okay, these cases are reset to October 29th, 2025. Ms. Reyes, you can get your reset from our court coordinator. Once you get your reset, you're free to go, and you have a blessed day.
Thank you, Dallas.
Okay, Mr. Macy, you like to approach?
Yes,
Okay.
I'm approaching on Quentin Hall.
Oh, no.
She's on the trial docket. She asked for oral motion for continuance, and I'm just trying to find out, do you want him to come back at 1:30 because he's on the trial docket, or do you?
Yeah, just have me come back and say, yeah, I told him I was gonna hold on it. I need to see. Yeah,
Have him come back at 1:30?
yeah, that'd be fine.
Okay. Thank you.
Go back. I'm not gonna wait. Oh, that's like- oh, no, you were close.
Well-
Okay,
This is cause number 25 CCCR 0504, case is styled State of Texas versus Charles Jason Kramer. Mr. Kramer, is that your full name?
Yes, sir.
How are you doing, Mr. Kramer?
Not well,
Hmm?
not very well.
Okay, well, I hope that you'll be doing a lot better before the day is over. Now, Mr. Kramer, now the state is represented in this case by attorney Shane Hilton. Mr. Hilton, how are you doing?
I'm good, Your Honor. Thank you.
You are. Mr. Kramer, your case was reset to give you opportunity to hire, I think it is here, Kevin Lane.
Well,
Have you hired Mr. Lane?
I actually attempted to hire Mr. Paget, and that didn't work out. So in the interim, I guess I'm proceeding pro se. I filed a motion to dismiss it. Quash.
Okay, so hold on a minute. Let's see. Hold on a minute. I'm gonna need a clipboard with the judge's explanation and the waiver. She's gonna give you that clipboard that has the judge's explanation of rights of defendants without attorney. Inform you as to what your rights are concerning your right to have an attorney. We went over this document before, and I think you signed your initial and signed stating you wanted to hire an attorney. Since you've changed your mind, you need to fill out another form.
I still intend to hire an attorney. I just haven't been able to yet.
Well, this has been taking too long.
Yes.
I mean, we've been around this, been doing this here for months. Every 30 days we come back, you tell us the same thing. Okay, now you just told us that you wanted to represent yourself. And so you have a right to represent yourself. We'll give you an opportunity to go over that clipboard. I can go over it briefly with you right now. Basically, it states that as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. You understand that option? You understand that option?
Yes, sir.
Okay, number two, if And the second option is on the number 2 that you may request that an attorney be appointed to represent. You understand that option?
I think that's the route I'd like to go.
Okay, I'm going down that clipboard with you so to make sure that you understand all of your rights. Okay, number 3, you may represent yourself. Do you understand that option?
Yes,
Okay, and that first paragraph below number 3 states that if you want an attorney, you have enough money to hire an attorney, you may, your case will be reset to give you an opportunity to hire an attorney. Do you understand that?
yes,
Now, the second paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. But you must first fill out a financial questionnaire so that the proper person can determine whether or not you qualify for a court-appointed attorney. Do you understand that?
yes.
Now, the third paragraph states, and that's for individuals who like to waive their right to an attorney and represent themselves. It states that you may not talk to the prosecutors unless you first sign a waiver of your right to be represented by an attorney. Now, the waiver, if you decided to represent yourself, is a one-page document that is on the clipboard. You would have to fill out, read, and sign that document. Do you understand that?
Yes.
Okay. Now, the second to the last paragraph is in block form. It states that be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney representing yourself may result in the worst outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. You understand that?
Yes.
Now, the last paragraph states that if you are representing yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Do you understand that?
Yes, sir.
Now, at the bottom of that document in bold letters, it states defendant's choice. Mark initials next to only one choice. Now, if your choice is to hire your own attorney, you place your initials on the first line to the left. If you have already hired an attorney to represent you, then you'll place your initials on the second line to the left. If your choice is to apply for a court-appointed attorney, you'll place your initials on the third line to the left. If you've already been appointed a court-appointed attorney in your case, you'll place your initials on the fourth line to the left and the name of the attorney in the line to the right. If your choice is to represent yourself, that is to waive your right to an attorney and represent yourself, then you'll place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your name on the line that is dated, that's titled defendant, and you was dated today's date, September 29th, 2025. Do you understand?
Yes, sir.
Okay. Okay. Now you may have a seat, make your choice, and fill out the necessary paperwork. Now, if you are applying for a court-appointed attorney, there's a 3-page document that is on the clipboard, and that document is titled Jefferson County Affidavit of Indigence. You would have to fill out the entire first page of that document, and on the second page, you have to fill out the top portion that is titled Defender's Oath, and the middle portion that is titled Unsworn Declaration by Defendant. Do you understand that?
Yes.
Okay. You can have a seat, and once you finish filling out the forms that needs to be filled out, then we'll call you back up. Okay.
Thank you, sir.
Okay, you're welcome. Yes. Yeah, hold on a minute. Let's see.
It's only an announcement docket for Ray knows.
Ray Anthony, no? Okay, this is cause number 25 CCCR 0612, case of style of state of Texas versus Ray Anthony No. Mr. No, is that your full name?
Yes, sir.
How are you doing, Mr. No?
I'm doing fine.
That's good. Mr. No, you're representing your case by your attorney, B. Eric Franklin. Mr. Franklin, how are you doing?
I'm fine, Judge. How are you?
I'm doing fine. Thanks for asking. And Mr. Franklin, what's your announcement in Mr. No's case?
Ready. We are ready for jury trial, Your Judge.
This is on the announcement. It's not on the trial docket.
Right, we're,
So you want to put it on the trial docket?
yes, Your Honor, we're
Okay.
announcing ready. I think we have a procedural issue. He's got parallel cases. This is an unlawful carry. And so the other, we've announced ready on the parallel cases that were the felonies that were in the other court. So,
When is the felony set?
well, we announced ready this morning, Judge, so I don't think it's been set yet for the trial docket.
Or it's the same criminal episode?
Yes, so that's what I wanted to
Right.
address with the court. Is I don't know how you would handle it because I think.
Well, normally we just set them on the same day of the felony.
Okay.
And just kind of
Monitor.
follow the felony because sometimes that's what the lawyers want to take care of the felony first.
Yes, Your Honor, we would love to do that.
Okay, what did you say?
It's still set for today.
Okay, so what we're gonna do that, there isn't a felony court date in the file. And so what we're going to do is monitor it. Once they give us a court date, once they give him a court date, then we'll reset this case on the same date of that date. Okay?
Yes.
So you're free to go. Stay in contact with your attorney and your bondsman, and you have a blessed day, Mr. No. And Mr. Franklin, you're free to go.
Thank you,
And-
Judge.
All right, and we'll get you your reset to you.
Thank
And
you.
you have a blessed day.
Thanks, Shay.
Thank you. Hey, Mr. Kramer? Okay, Mr. Kramer, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line as titled Defendant?
Yes, sir.
And are these your initials on the line? Well, first of all, let me do this here. Would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Kramer, you may put your hand down. Now, Mr. Kramer, this first document, Judge's Explanation of Rights to Defendants Without Attorney. Is this your signature on the line as titled Defendant?
Yes,
And are these your initials on the line that state you'd like to waive your right to an attorney and represent yourself?
yes,
I also have another document that is titled Waiver of Counsel for purposes of entering guilty plea or proceeding trial. Do you recognize this document?
yes, sir.
And is this your signature on the line as titled Defendant?
Yes, sir.
Mr. Kramer, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay, so Mr. Kramer. I'm going to. Now, Mr. Kramer, I'm going to need to give you an admonishment and pursuant to the case of Ferretta versus California, 422 US 806. Now, have you ever studied law?
Briefly.
Okay, you-
took business law at college.
Okay. Have you ever represented yourself in a criminal action?
Yes, sir.
Okay. Do you understand the charge against you?
Yes, sir.
Okay. Now, are you aware of the penalty range for this charge?
Yes, sir.
Okay. Are you aware of the exact legal elements for this charge?
I've done some research now, because I had never heard of what I was charged with. ever.
So you're familiar with the elements, what the state has to prove?
Yes, sir.
Okay.
That's what led me to file the motion.
Okay, Now, do you realize if you represent yourself, that you're on your own?
Yes, sir.
Mhm.
And as a judge, I cannot help you in any way. I can't tell you how to try your case or even advise you as to how to try your case. Do you understand that?
Yes, sir, I do.
All right. Are you familiar with the Texas rules of evidence and Texas case law? Do you realize that the Texas rules of evidence and Texas case law govern what evidence is admitted? And in representing yourself, you must abide by those rules.
I'm gonna intend to do a lot more research on it.
Okay. And for example, do you know how to conduct a voir dire examination?
No, sir, I do not.
Okay. And do you know what are the grounds for excusing a juror for cause?
No, sir.
And do you know, I guess, the legal definition of hearsay?
I think so.
Okay. And do you know some of the exceptions to the hearsay rule?
No, sir.
Okay. Do you know when and how to make proper objections?
No, sir.
Okay. Do you know when and how to move for a directed verdict?
Yes, sir.
Okay. Do you know how to offer evidence to protect the record for appeal?
No, sir.
Okay. Do you know the proper grounds for a mistrial?
No, sir.
Are you aware that failure to timely move for a mistrial may waive crucial mistakes made by the state in this case?
I do now.
Okay. Do you know how to request and object to a jury instruction?
No, sir.
Okay. Are you familiar with the Texas rules of criminal procedure?
No, sir.
Do you realize that those rules govern the way in which criminal actions is tried in court?
Yes, sir.
Okay. I must advise you that in my opinion, you would be better defended by a trained lawyer than you can by yourself. I think it is unwise for you to try to represent yourself. You are not familiar with the law. You are not familiar with the court procedure. You're not familiar with the rules of evidence. I would strongly urge you not to try to represent yourself. Now, in light of the penalty that you might suffer if you are found guilty, and in light of all the difficulties of representing yourself, is it still your desire to represent yourself and to give up your right to be represented by a lawyer?
I'd like to have a hearing over the motion that I filed.
Okay, but you're not, listen to my question. The question was, now in light of the penalty that you might suffer if you are found guilty, and in light of all the difficulties of representing yourself, is it still your desire to represent yourself and to give up your right to be represented by a lawyer?
And the paper that I signed, I can still.
Yeah, but my question to you now is that's what you want to do? Okay. Now, okay, and is your decision entirely voluntarily on your part? All right. So I find that the defendant has knowingly and voluntarily waived his right to counsel. I will therefore permit him to represent himself in this case. And so this case is going to be reset. I know you stated earlier that you would like to file some pretrial motions.
I already did.
You already did? Okay, well, we'll have to set it for a hearing. Okay. Give us a hearing date. He said he filed some pretrial motion. Pull up his file and see.
I don't see that the state has received any motion.
When did you file it?
This weekend.
Oh, this weekend. So they probably haven't taken it in. We have to have an e-file motion, and then the state has to receive a copy of it too.
Envelope number 106-17173.
You might need to check with the county clerk's office to see if they received it or if they rejected it. Sometimes, motions have to be filed in a certain manner. And so if they're not properly filed, sometimes they get rejected.
Check downstairs.
You'd have to check with them to see if it's been received and whether or not it's been accepted or rejected.
Yes.
Okay, so right now, let's just give him a regular court date. And then the state has to get a copy of the motion too. Okay,
The certificate of service was included in it. But the only thing I have right now is the envelope receipt.
okay. Well, if they reject it,
For rejection.
yeah, if they reject it, then he wouldn't get it. We don't know what the status is right now, but you can check with them. We're gonna reset your case. Let's see, October 27th. Okay, your case will be reset to October 27th. All right, you get your reset. Once you get your reset, you're free to go and you have a blessed day.
You too.
You did. Here you go. Is that Everett? Walton James Everett the third. Who's the prosecutor? She was that. Jefferson County Court at Law number 2 is back in session. Court is in session and calls number M333-482. Case is styled the state of Texas versus Walton James Everett III. And Mr. Everett, is that your full name?
Yes.
Mr. Everett, would you please raise your right hand? Mr. Everett, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Everett, you may put your hand down. How are you doing, Mr. Everett?
All right, how are you doing?
I'm doing fine, thanks for asking. Mr. Everett, you're represented in your case by your attorney, Attorney Jansen Bailey. Mr. Bailey, how are you doing?
I'm doing well, Your Honor. Thanks for asking.
You're welcome, Mr. Bailey. Do you waive a record in Mr. Everett's case?
Yes, Your Honor.
Mr. Everett, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Everett, it alleges that you, Walton James Everett III, on or about March 26th of 2022, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of driving while intoxicated while you were operating a motor vehicle in a public place in Jefferson County, Texas. Mr. Everett, do you understand what you have been charged with?
Yes.
To this charge, Mr. Everett, how do you plead? Guilty, not guilty, no contest?
I'm guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you are guilty?
Yes.
Okay, Mr. Bailey,
Oh, thank
you need to check that, the box below that Class B, that box is for
Oh,
DWI.
yes.
Okay, now, Mr. Okay, Mr. Everett, I also have another document on this tablet that is titled Misdemeanor Plea Admonishments. This document is also labeled as State's Exhibit number 1. Do you recognize this document?
Yeah.
Now, the third box is checked on as stating that this is a Class B misdemeanor DWI. Range of punishment for a Class B misdemeanor DWI is a minimum 72 hours in the county jail up to 180 days. A fine that does not exceed $2,000, or you could be given both such fine and confinement. Do you understand the range of punishment for a Class B driving while intoxicated case?
Yes.
On page 2 of this same document, there's a set of initials, WE, on a line next to a box that's checked guilty. Did you place your initials on this document?
Yes.
On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes.
And on the next document that's titled trial court certification of the defendant's right of appeal, do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
I also have a document on paper that is titled discovery certification. Do you recognize this document?
Yes.
Is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Everett, before you signed and initialed all of these documents that I just showed you, did your attorney, Mr. Bailey, go over these documents with you?
Yes.
Did you understand everything that Mr. Bailey went over?
Yes.
Is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Everett, are you a citizen of the United States?
Yes.
State office next one.
Any objections?
No.
Basic. Okay, no objections. State's Exhibit number 1 will be admitted. Mr. Bailey, you advised in counsel, Mr. Everett, is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Everett, Mr. Bailey has advised and counseled you. Are you satisfied with his representation?
Yes.
Has he provided full, effective, and competent legal representation?
Yes.
Mr. Everett, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
State's offering 1 year deferred with a $750 fine, 40 hours community service, the installation of an interlock device, and DWI for standard conditions of probation.
What's the court cost?
Mm.
Okay, Mr. Everett, state is offering that you serve 1 year deferred adjudicated probation during the 1 year probationary period. You'll be required to pay a fine of $750 plus court costs of $392. You'll be required to pay a DWI conviction fine fee of $100. You'll be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. And you'll be required to pay a DWI education and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation is $196 a month. Would you be able to pay the $196 each month?
Yes.
You will also be required to perform 40 hours of community service, install an interlock device on any vehicle that you own or operate, attend a completed DWI education class, have an alcohol assessment, and adhere to the other standard terms and conditions of this probation. Now, Mr. Everett, do you understand the state's offer?
Yes.
Do you think that the state's offer in your case is fair and just?
Yes.
And do you accept the state's offer?
Yes.
Mr. Everett, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Everett, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for non-disclosure. You can talk to your attorney about the non-disclosure because he's quite competent in those matters.
Yeah.
Now, Mr. Everett, you're gonna stand at the end of that table, follow the directions of the bailiff. Once you finish following the directions of the bailiff, you'll be free to go,
All right.
and you have a blessed day.
How are you?
And Mr. Bailey, you have another case?
Yes, Your Honor. So I have another case.
Is it
Isaac.
Isaac Stoneham?
He is not present right now. He is on Zoom. He called,
Oh,
called
he-
in my office at
he
5.
is?
Yes, he's, I think it's the Galaxy.
Okay, Isaac Stoneham, you could take your mic off of mute. Okay,
Yes, sir.
okay, how you doing, Mr. Stoneham?
I'm doing fine and yourself.
I'm doing fine, thanks for asking. Now, Mr. Bailey, what's your announcement in Mr. Stoneham's case?
Your Honor, this was gonna be a plea case. My client's driving in from Austin. He had automobile trouble at 5 this morning. He did call my office and alert me to it, but I assumed that you might want to speak with him, so I told him to be available on Zoom.
So we just need to reset it?
Yes, it's gonna be a plea.
Okay. We could reset it a week or two,
2 weeks is fine.
2 weeks. Give us a 2-week reset.
October 13th.
Okay, this case will be reset to October 13th, 2025. Mr. Stoneham, your attorney and your bondsman will be given notice of your resets. Stay in contact with your attorney and your bondsman. You're free to go. And Mr. Stoneham, we hope that everything turns out well with your vehicle and that you're safe. You're free to go. Stay in contact with your attorney and your bondsman, and you have a blessed day.
Thank you, Judge.
Yes, sir. Thank you, Your Honor.
Okay, you're welcome. Yes.
Hmm.
How about that?
Remember last time I did that and I got into confusion. That was horrible.
Okay, ma'am, please put your mic on mute. Person on Samsung SM, please put your mic on mute.
Maybe.
I have to mute it. I'll mute it for you. Okay. Okay. Let's see, this is John Glenn Duhon.
Sir,
Okay, how you doing, Mr. Duhon?
good, sir, how are you?
I'm doing fine, thanks for asking. Mr. Duhon, you're represented in your case by your attorney, Tom Burbank. Mr. Burbank, how are you doing?
Doing fine, Judge.
That's good. Now, Mr. Burbank, what's your announcement in Mr. Duhon's case?
I made an offer to the state judge. I guess they're rejecting it.
Okay, it's on the trial docket, so y'all ready?
Ready?
Could be ready.
Okay, okay. The case, okay, so Mr. Duhon and Mr. You'll be back at 1:30. That's when we pick out jury, okay?
Is there any way we can reset it? My dad's having a procedure done today at the hospital. I didn't know.
I didn't realize it is.
I had not changed it.
Well, you did talk to your attorney about that. He said now it's ready.
What, can we just, before we sit down, can you tell us what procedure?
Well, let me do this. We on Zoom. We don't need to put it all over blast it all over the world.
It's been a camera up in his leg.
Well, no.
So,
That's all right. I thought we were going to say it.
so the oral motion for continuance by the state, by the defense, state, no objection, right?
No objection, Your Honor.
November the 3rd. Okay, this case reset for trial November 3rd. Okay, you can get your reset from our coordinator, you're free to go. And we'll be praying that your father have a successful service.
Sir.
All right. Andrew Chase Hoosier. Oh, yeah, did that yet? Okay, just hold on. She's working on it right now. Now, who do we have?
And I also have Mr. Brown. Judge.
Yeah, that's another.
That's another plea. Okay, she's working on it.
I'm having issues getting the discovery log to print,
Okay,
but I'll keep working on
okay. Is it Lofton? James J. Lofton?
As we can counsel, Your Honor. No, we approach.
Yes. He's on the docket. Okay. This is cause number 24 CCCR 2300, case is style of state of Texas versus James J. Lofton. Mr. Lofton, is that your full name?
Yes, sir.
Mr. Lofton, would you please raise your right hand? Mr. Lofton, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Lofton, you may put your hand down. How are you doing, Mr. Lofton?
All right.
That's good. Mr. Lofton, you're represented in your case by your attorney, Dallas J. Barrington. Mr. Barrington, how are you doing?
Good, Your Honor.
And Mr. Barrington, do you waive a record in Mr. Lofton's case?
We do, Your Honor.
Mr. Lofton, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Lofton, it alleges that you, James J. Lofton. Let's see, on or about December 15th of 2023, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class A misdemeanor offense of driving while intoxicated. Second, this information further alleges let's see, that prior to the commission of this offense, that on March 1st of 2011, in cause number 63434 in Hardin County Court of Hardin County, Texas, that you were convicted of an offense relating to the operating of a motor vehicle while intoxicated. Is that true or not true?
True.
Okay. Now, to the Class A misdemeanor offense of driving while intoxicated, how do you plead? Not guilty, guilty, or no contest?
Guilty.
Guilty. Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Mr. Lofton, I also have before me a document on my tablet that is titled Misdemeanor Plea Admonishments, is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yeah.
On page 2 of this same document, there's a set of initials, JL, on a line next to a box that's checked guilty. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box is checked, states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
I also have a document on paper that is titled Discovery Certification. Okay. Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
Now, before you sign and initial these documents, did your attorney go over these documents with you?
Yes.
And did you understand everything that your attorney went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Sir.
Mr. Lofton, are you a citizen of the United States?
Yes, sir.
State offer State's Exhibit 1.
No objection, Your Honor.
Okay, no objection. State's Exhibit Number 1 will be admitted. Mr. Barrington, you've advised and counseled Mr. Lofton. Is there any evidence that he is currently mentally incompetent to stand trial?
None, Your Honor.
And Mr. Lofton, your attorney, Mr. Barrington, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Lofton, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State. Do we have a plea bargain agreement?
Yes, we do, Your Honor.
What's the agreement?
We'd ask the court for 10 days county jail with credit for 2 days, repayment of court costs. And we'd ask that this sentence run concurrent with the sentence on a felony motion to revoke probation for cause number F16-24485-0.
Now, this is a class, this is class A misdemeanor. DWI second or minimum days is 30. You can't give
Your
below
Honor,
the
they
minimum.
will abandon the enhancement to go with the agreement.
Okay.
Objection, Your Honor.
Okay, so they're gonna have to redo the paperwork. Okay. So I'm gonna have to let me redo this. Okay,
I think, Your Honor, I think the only thing that needs to be done is.
no, I'm gonna have to, at mine, he pled to a
Oh.
class A, now he's gonna have to plead to a class B. Okay?
Yeah, yes, sir, Your Honor,
Okay.
that's fine.
So, let me do this here. Now, Mr. Lofton, I have before me a document that is titled, information. This information was filed by the Jefferson County District Attorney's Office. Now, in this information, it alleges that you, James J. Lofton, on or about December 15 of 2023, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated. Second, now state, are you abandoning the enhancement paragraph?
Yes, Your Honor.
Okay. And the state is abandoning enhancement paragraph, Mr. Lofton, and what that means is instead of being charged with a Class A misdemeanor DWI second, you'll be charged with a Class B misdemeanor DWI first. Do you understand that?
Yes, sir.
All right. Now, to the Class B misdemeanor DWI first, which allegedly occurred on or about December 15 of 2023 while you were in Jefferson County, Texas, how do you plead? Guilty, not guilty, no contest?
Guilty.
Now, are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Okay. Now, Mr. Lofton, I need to write that on here. Hold on a minute. DWI first. First. I'm gonna go ahead and change the box that's checked DWI second.
That'd be
DWI
fine, Your Honor.
first.
No objection.
Okay. Okay, now, Mr. Lofton. I have before me a document that is titled Misdemeanor Plea Admonished for States Exhibit 1. On page 1, I've checked the first box that's titled DWI first. And the range of punishment for DWI first is minimum 72 hours to a maximum of 180 days in the Jefferson County Jail. Or a fine that does not exceed $2,000, or you could be given both such fine and fine. Do you understand the range of punishment for DWI first?
Yes, sir.
All right. On page 2 of this document, these are your initials, JL, on the line that's titled guilty. Is that correct?
Yes, sir.
And your signature is on page 3 above the line that's titled defendant.
Yes, sir.
And on the next document, that's titled trial court certification of defendant's right of appeal. This is your signature.
Yes,
Is that right? And there are 2 boxes checked. The first box that's checked states that this is a plea bargain case. You have no right of appeal. And the second box that's checked states that you're waiving your right to an appeal. In this case, do you understand that?
Yes, sir.
And you previously acknowledged the trial court certification of discovery. Is that correct? That's the document that was on paper.
Yes.
Okay. Now, and the court previously found that you were mentally competent to stand trial. Now, and you acknowledge that you're satisfied with the services of your attorney, is that correct?
Yes, sir.
He's provided full, effective, and competent legal representation. All right. Now, Mr. Lofton, I will accept your plea of guilty to the Class B misdemeanor offense of DWI first. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt state. Do we have a plea bargain agreement?
Yes, we do, Your
And
Honor.
what's that agreement?
Your Honor, we'd ask the court for 10 days county jail with credit for 2 days time served, repayment of court costs, and has this sentence run concurrent with the sentence for a felony motion to revoke on cause number 516-24485-0.
Repeat that number.
F16
F16
244
244
85
85-0.
0.
Okay, that's the felony SCC with that. Okay.
Yes, Your Honor.
Okay. What's the court cost? Hold on a minute. Okay, Mr. Lofton, the state is offering that you serve 10 days in Jefferson County Jail. You'd be given credit for the 2 days that you've already served. The court cost in this case is $392. Are you able to pay the $392 a day?
No, Your Honor, we would ask that he be allowed to serve that as part of his time. If he is going to safety,
Oh, okay.
it's a probation
Okay.
revocation felony court.
Okay, yeah, okay. Well, let me do this here.
So, I think it's like Class C.
Does he have an affidavit of innocence?
I don't know.
Judge, it's fine with us if you just render judgment for the court cost.
Yeah, but I mean, if I mean, if you say he's going to safety,
Yes, sir.
so he's not gonna have an income.
Correct.
Right, so the court has could find that he's indigent pursuant to Article 42.15 of the Texas Code of Criminal Procedure. And since the court found him indigent, the court cost of $392 in this case will be waived.
Fair enough, Your Honor.
Okay,
Thank you.
okay,
Appreciate the help.
okay. 42.15 Texas. Now, Mr. Lofton, do you understand the state's offer? You think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Mr. Lofton, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Lofton, you're gonna stand at the end of that table. Is the paperwork? Okay, it's not ready yet. Just have a seat in the jury box, and then when the paperwork is ready, then you'll follow the directions of the bailiff. Once you finish following the directions of the bailiff, you can follow the bailiff. You have a blessed day. All right, you can have a seat, and Mr. Barrington, you're free to go, and you have a blessed day.
Thank you, Your Honor. May I be
Okay,
excused?
yes, you
Thank
may.
you. Thank you. Appreciate it.
Yeah, it's good to see you.
See you.
That door is locked. Dallas, okay. Let's see. We have anybody else? Hoosier. Andrew Hoosier. Going on, dismissing 30. Okay. Jefferson County Court Law number 2 is in session in 2 cases. Cause number 23 CCCR 0430 and cause number 24 CCCR 0433. Both cases are styled the state of Texas versus Andrew Chase Hoosier. Mr. Hoosier, is that your full name?
Yes.
Mr. Hoosier, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may put your hand down. How are you doing, Mr. Hoosier?
Okay.
That's good. Mr. Hoosier, you're represented in your cases by your attorney Tom Burbank. Mr. Burbank, how are you doing?
Doing fine, Judge.
And Mr. Burbank, do you waive a record in Mr. Hoosier's case?
We do.
And Mr. Hoosier, I have before me in cause number 23 CCCR 0433, a document that is titled Information Sheet. This information sheet was filed by the Jefferson County District Attorney's Office in this information sheet, Mr. Hoosier, it alleges that you, Andrew Chase Hoosier, on or about February 20th of 2023, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of interfering with emergency requiring for assistance. He had to check the box. It's Class A, okay. Now, Mr. Hoosier, do you understand what you've been charged with?
Yes.
And to this charge, Mr. Hoosier, how did you plead? Guilty, not guilty, no contest? Now, are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges?
Yeah.
So Hoosier, I also have before me a document on my computer tablet that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit number 1. Now, Mr. Hoosier, do you recognize this document?
Yes.
Okay, now you notice that there's one box that's checked. The box that's checked states that this is a plea bargain case and you have no right of appeal. Well, actually, the box that's checked states that this is a Class A misdemeanor, and the range of punishment for a Class A misdemeanor is minimum 0 days to maximum of 365 days in the county jail. A fine that does not exceed $4,000, or you can be given both such fine and confinement. Do you understand the range of punishment for a Class A misdemeanor? On page 2 of the same document, there's a set of initials. On 2 sets of initials, one set is your attorney initials, the other set, AA or AH, excuse me, is next to your attorney's initials. On the line next to a box says check no content rate, which means no contest. Did you place your initials on this document?
Yes. First page, Rollins. What was that one? It's just a statutory possible punishment for which case. That's in. Yes, I understand.
Okay. Let's see. And this is your signature on page 3 of this document. Is that correct?
Yes.
Now, on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, you recognize this document? And is this your signature on the line that's titled Defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have another document on paper that is titled Discovery Certification. Do you recognize this document? And is this your signature on the line that's titled Defendant? Now, Mr. Hoosier, before you sign and initial all of these documents that I just showed you, did your attorney go over these documents with you?
Yes.
Did you understand everything that your attorney went over?
Yes.
Is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Hoosier, are you a citizen of the United States?
Yes.
State,
For State's Exhibit 1.
any objections? No objections? State's Exhibit number 1 will be admitted. Now, Mr. Burbank, you advised and counseled Mr. Hoosier. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Okay, Mr. Hoosier, your attorney, Mr. Burbank, has advised and counseled you. Are you satisfied with his representation?
Yes.
Has he provided full, effective, and competent legal representation?
Yes.
Mr. Hoosier, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers are freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is the agreement?
Your Honor, we'd ask the court for 7 days county jail with credit for time served of 7 days. And that's that the court costs in this matter be taxed and retired. And in agreement for the plea to this charge, the state agrees to dismiss the companion case, cause number 23 CCCR 0430.
Okay, Mr. Hoosier, the state is offering that you serve 7 days in Jefferson County Jail, but you would not have to serve any more time in the Jefferson County Jail because you already served 7 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Mr. Hoosier, do you understand the state's offer?
Yeah.
And also, in addition, the state will be dismissing cause number 23 CCCR 0430. Now, Mr. Hoosier, do you think the state's offer in this case is fair and just?
Yes.
And do you accept the state's offer?
Yeah.
Okay, Mr. Hoosier, I'll follow the pre-bargain agreements that you have entered into with the state. Mr. Hoosier, you can stand in front, stand at the end of that table, follow the directions of the bailiff. Once you finish following the directions of the bailiff, you'll be free to go and you have a blessed day.
May you be excused, Your Honor.
Yes, he may be excused after, let's see.
No, the bailiff, just, leave it right there, just wait on the bailiff. And I need the first.
On Hoosier? Okay, yeah, I'm signing the dismissal, Mr. Hoosier. You be able to get a copy.
Look.
You got it? Let's see.
She said she's home, we should. Is that no?
William Timothy Brown? That's one of yours. Do we have Mr. Brown's ready?
We do, Judge.
Do you have Mr. Brown ready?
Oh.
Here.
Does he?
It wasn't showing up. It wasn't showing up, yes.
Is that? Oh, I'm fine. I didn't want to push it. Then we get your business. There's a third maybe.
November 32, okay. Okay, this is cause number M331945, cases style state of Texas versus William Timothy Brown. Mr. Brown, is that your full name?
Yes, Your Honor.
Mr. Brown, would you please raise your right hand? Mr. Brown, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Mr. Brown, you may put your hand up. How are you doing, Mr. Brown?
Pretty good yourself.
I'm doing fine, thanks for asking. Mr. Brown, you representing your case by your attorney Tom Burbank. Mr. Burbank, do you waive a record in Mr. Brown's case? Mr. Brown, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Brown, it alleges that you, William Timothy Brown, on or about November 13th of 2021, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated while you were operating a motor vehicle in a public place in Jefferson County, Texas. And this is charged with driving while intoxicated with an alcohol concentration level of 0.15 or more. State, are you abandoning the enhancement paragraph?
That's correct, Your Honor. State so moves.
Okay. Now, Mr. Brown, the state is abandoning the enhancement paragraph. And what that means is, instead of being charged with a Class A misdemeanor DWI, you'll be charged with a lesser included Class B misdemeanor offense DWI. So to the Class B misdemeanor offense of driving while intoxicated, which allegedly occurred on or about November 13th of 2021 while you were operating a motor vehicle in a public place in Jefferson County, Texas. How do you plead guilty? Not guilty, no contest.
No contest.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Mr. Brown, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a set of initials. Okay, there's 2 sets of initials on the line next to a box that's check no look Kendra. One set of initials is your attorney initials. The next set of initials, are these your initials next to your attorney's initials?
Yes.
On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes.
And on the next document that's titled trial court certification of defendant's right of appeal, you recognize this document.
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box is checked, states that this is a plea bargain case and you have no right of appeal. You understand that statement?
Yes, sir.
The second box is checked, states that you're waiving your right to appeal, which means you're giving up your right to appeal. Do you understand that statement?
Yes.
I also have a document on paper that is titled discovery certification. Do you recognize this document?
Yeah.
And is this your signature on the line that's titled defendant?
Yes, sir.
Now, Mr. Brown, before you signed and initial all of these documents that I just showed you, did your attorney explain these documents to you?
Yeah.
And did you understand everything that your attorney explained?
Yes.
And is everything in these documents true and correct
Yes,
to
sir.
the best of your knowledge? And Mr. Brown, are you a citizen of the United States?
Yes, sir.
State Offer States Exhibit 1.
No objection, states one.
No objection, states exhibit number 1 will be admitted. Mr. Burbank, you've advised in counsel, Mr. Brown, is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Brown, your attorney, Mr. Burbank, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Brown, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is the agreement?
Your Honor, we'd ask the court for 12 months of deferred adjudication with a fine of $500, repayment of court costs, 40 hours of community service, the requirement of the interlock device, and the standard terms and conditions of probation for a DWI first. Huh. Yeah, pension.
It's not, yeah, oh, it is, show it, you have a drug, yeah, DWI first intervention program, that's the same thing as the that's the same thing as DWI education.
Yeah, just whatever programs.
Yeah. It's the same thing as DWI education, because I don't think there's oh, no, it's not. Let's see, you can take a look at it, see the box that's checked. See, the
Yes, Your Honor.
education is already,
Yeah, it should just be the gray box, the DWI education class and the alcohol assessment. There was not a
interlock,
intervention program. The interlock is required
okay,
as part of the plea.
right,
The intervention program was not.
okay.
But if you want to.
What's the court cost? $392, okay. Okay. Okay, this is, okay, now, Mr. Brown, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $392. You'll also be required to pay a DWI conviction fine fee of $100, probation fee of $6 a month, your announcement fee of $15 a month, reimbursement fee of $15. Your total monthly installments, well, you'll also be required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you'll be required to pay each month while you're on probation, is $173 a month. Will you be able to pay the $173 each month? You'll also be required to perform 40 hours of community service, install the interlock device on any vehicle that you own or operate, attend a completed DWI education class, have an alcohol assessment, and adhere to the other standard terms and condition of this probation. Mr. Brown, do you understand the state's offer?
Yes, sir.
Do you think the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes.
Okay, Mr. Brown, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Brown, you're gonna stand at the end of that table, follow the directions of the bailiff. And once you finish following the directions of the bailiff, you're free to go. And you have a blessed day.
Thank you.
You're welcome.
My name is Stephen. May I be excused, Your Honor?
Yes, you may. Mr. Kelly?
Yes, Your Honor.
Thang Lang, is that Quash?
Yes, that's.
Okay, and she's on Zoom. She has 2 cases. What happened? I think she put it on mute and turned the video off. Okay. Okay, Ms. Quash, how are you doing? Okay, she has it on mute. Ms. Quash is represented in this case by her attorney, Attorney Tom Kelly. And Mr. Kelly, how are you doing?
Great, Judge. Good Monday to you.
Same to you. And Mr. Kelly, what is your, this case set on the trial docket? What's your announcement?
Your Honor, the state has a motion on both of these charges. We'd be moving to dismiss.
Oh,
I've submitted them to the clerk, just a few.
Oh,
minutes ago, so
okay.
they-
okay, just received. Okay. And Mr. Kelly, I assume you don't have any objections?
I really don't have any objections to this. At all, Judge. I thought about maybe. I decided to stop talking.
Okay, now, Ms. Quash, both of these cases will be dismissed. You can get a copy of the dismissals from our county clerk's office. You're free to go, and you have a blessed day. Okay. Okay, Mr. Kelly, this is the only 2 cases you have?
Margarita Loza is also present on Zoom.
Okay. Okay, let me finish signing these. Okay, this is cause number M333-712, case to style the state of Texas versus Margarita Loza. Ms. Loza is appearing via Zoom. And Ms. Loza, how are you doing?
Doing good. How are you?
I'm doing fine. Thanks for asking. Ms. Loza, you're represented in your case by your attorney Tom Kelly. And Mr. Kelly, this case is on the pre-trial conference docket. Mr. Kelly, what is your announcement?
I suppose we need to stay on this docket, Judge.
Okay.
I guess unless that means you're moving us to the trial docket. which-
Yeah, I mean, we've had it for a while here. So we'll reset it on the trial docket. Okay, give us a trial date. November 3rd. This case is reset for trial November 3rd, 2024. 2025. Ms. Loza, on that day, you need to be in court in person at 9 a.m. on November 3rd, 2025. Stay in contact with your attorney, your bondsman. They will be given notice of your reset date. You're free to go, and you have a blessed day.
Thank you. You too.
Oh, you're welcome. And Mr. Kelly, is this your last case?
My last case,
Okay.
Your Honor, if you'd allow me, I'm gonna handle Mr. Gertz's announcement if I could.
Okay, Kurt.
So,
Is that Ryan Pete?
Yeah, I believe he's present on Zoom.
Okay, Mr. Pete is currently on Zoom. Mr. Pete. See, we have two cases for you. Cause number is 25 CCCR 1164 and cause number 25 CCCR 1165. Both cases are styled the state of Texas versus Ryan Baxter Pete. Mr. Pete, is that your full name?
Yes, sir.
How are you doing, Mr. Pete?
I'm doing well, sir. How are you doing?
I'm doing fine. Thanks for asking. Mr. Pete, you're represented in your cases by your attorney, Attorney Ryan Gertz. Mr. Gertz is not here. However, standing in for Mr. Gertz is Mr. Tom Kelly. Does Mr. Kelly have your permission to stand in for Mr. Gertz?
Yes, sir.
Okay. And Mr. Kelly, what is your announcement on behalf of Mr. Gertz?
Your Honor, if we could stay on this docket, please. It sounds like
Keep it on announcement?
there's
Okay.
an issue that may lead to a resolution.
Okay. Give us an announcement date.
October 27th.
Okay, this case will be reset to October 27th of 2025 at 9 a.m. Mr. Pete, your attorney, your bondsman will be given notice of your reset date. Stay in contact with your attorney, your bondsman. Again, your case is reset to October 27th, 2025 at 9 a.m. You're free to go, and you have a blessed day.
Thank you, sir. You too.
Okay, you're welcome. Let's see, he have any more announcements? I don't think he has any more.
I think that was it.
Okay, you're free to go, Mr. Kelly.
Thank you, Your Honor.
All right. Let me see. Did, is Haley gonna handle it? Is Haley? We have, you wanted to
On Hall?
Hall? Yes, Mr. Hall?
Now I have.
Let's see. We got. Okay. So, okay, he had, let's see. Is it? Oh, here it is right here. So, we have, Mr. Hall. Is that correct?
Yes, sir.
Okay, so, you had an oral motion for continuance?
Yes, Your Honor. The state just wanted to re-urge that motion. We spoke with a witness who we have not been able to make successful contact with until this morning. She's spoken with me. She's also spoken with a defense attorney. The evidence in nature is exculpatory, and we want to make sure it's essentially exculpatory. And the state does in fact need time to meet with her to confirm all that information.
Okay. You have any objections?
No, Your Honor.
Okay, no objections. Okay. Give us a reset date
With that.
on the trial docket, page 4. Case reset November 3rd, 2025. Mr. Hall, you can get your reset from our court coordinator. Once you get your reset, you're free to go. You have a blessed day.
Thank you, Your Honor.
And let's see, we got Mr. Tillman set for trial at 1:30, right?
Yes, sir.
Okay. See. Okay. Let's.
Right? Right for the line? Right? I think right, yeah, they know.
You have the Flores Espinoza? Betia Flores Espinoza? Ms. Flores Espinoza, your first name is Betia Flores Espinoza, full name? How are you doing?
Good, thank you, how are you?
I'm doing fine, thanks for asking. And Ms. Espinoza, or Ms. Flores Espinoza, you represented by your attorney Ryan Matuska. Mr. Matuska, how are you doing?
Good morning, Your Honor.
Good morning. And Mr. Matuska, what's your announcement?
Your Honor, it looks like we're going to resolve this case, but I'm waiting on some information, so we're gonna ask for the one we said. Information.
The state has no objections. I've already spoken to defense about it, Your Honor.
Okay, give us a reset date. October 27th. Okay, this case is reset to October 27th of 2025. Ms. Flores Espinoza, you can get your reset from our court coordinator. Once you get your reset, you're free to go and you have a blessed day.
Thank you, Your Honor.
Thank you. And Mr. Matuska, this is your only case. You're free to go as well and you have a blessed day.
Did you go?
No.
Court will be in recess until 1 for our jury trial docket.